Hi everyone, and welcome to today's webinar. My name is Shannon Switek, and I work under the HOPP program here at the Empire Justice Center. First, I'd just like to note that today's webinar is made possible by the New York State Attorney General's Homeownership Protection Program. So before we get started, I want to let you know how you can interact with us today. Everyone has entered this webinar in listen-only mode, so if you have a question on the material being presented during the webinar, enter your question using the questions pane located on your control panel. Questions will be addressed both during and at the end of today's presentation. I'd also like to draw your attention to a new feature on GoToWebinar, or a newer feature, called Handouts. And Handouts is where you will find today's webinar materials, as well as the attorney affirmation form. So for today's CLE, we will be providing 1.5 CLE credits in the professional practice category. To receive your CLE certificate, please record the verification code on your attorney affirmation form when it's announced at the end of the webinar, and send your completed certificate to Michelle Peterson's attention, who is our training manager. The CLE code will also appear in the chat box on your control panel again at the end of the webinar. For non-attorneys, a certificate of attendance can be provided. You can email Michelle Peterson directly to request that certificate. Also, at the end of the webinar, you'll be asked to complete a webinar evaluation, and please do take a moment to complete that evaluation. So with our housekeeping out of the way, I'd like to turn it over to the webinar moderator, Becky Keiko.
Thanks, Shannon. So I just thank you, Shannon, for stepping in. Michelle Peterson had to she had to be out of the office for today, and Shannon has been gracious enough to help out. So technologically, Shannon's going to keep things running smoothly in the background, so thank you. With that, we have Richard Berkeley today, who is he works with what we call PULP, but it is the Public Utility Law Project of New York, and he's the executive director. And I'm very pleased to have him. This is not directly related to the work that we do as foreclosure defense advocates, but certainly, as you know, when folks walk in our door, they rarely have just one issue, and quite commonly you will see things like they are behind with their utility bills, or they have some other issues that they're running up against. And this is, I think, a great supportive offering that Richard is giving us today. So with that, thank you, Richard, for being willing to speak with us folks, and take it away.
It's my pleasure. Thank you, Becky, and thank you, Michelle. Hi, all. This is Richard Berkeley. I'm the executive director of the Public Utility Law Project of New York. We are a 35-year-old not-for-profit public interest law firm. Our mission is very simple. We advocate, litigate, and educate on behalf of low-income public utility consumers in the state. We are, in a very real aspect, the state's independent consumer advocate. So today I'm going to be talking about getting and keeping utility service. And for those of you who have practiced in this area before, this is all pretty much deriving from the Home Energy Fair Practices Act. But before I get into that, let me give you a little housekeeping. We have a website, utilityproject.org, and that is oriented at people who are very interested in the area of public utility consumer law. We also have a Facebook page, Utility Project, that's much more sort of public interested focused. And then, and forgive me while I keep fighting with my my PowerPoint, we also have a Twitter feed that we just pretty much report on the news on that. And so bear with me while I go back to my slideshow and keep it from turning itself. So we have an 800 number and email and a regular snail mail address, so you can get in touch with us in a number of different ways, and I'll bring that up again in the end. So let me start by talking about the Home Energy Fair Practices Act. The Home Energy Fair Practices Act is the benchmark for providing assistance to utility consumers in the energy area in the state of New York. And As you can tell, I'm still fighting with my PowerPoint, so bear with me while I try and bring it back under control. Let's see if that does it now, and bear with me, please. All right, so I'm going to talk a little bit about
Richard, I'm not sure if you can hear us, but something happened with your phone. All right. Shannon, I'm going to try to call him. I'm not sure that he's aware that there's an issue.
All right.
Hello? Hello? Yeah.
Hold.
It kicked off when I dial back in. I'm now on hold.
Sorry, who is this?
All right, sorry about that. I realized that I put everybody on hold music. I apologize. Richard is dialing back in. He got kicked off accidentally somehow. Let's see. Richard, are you there yet?
Yes, I am.
All right, let's start all over again, shall we?
Okay.
You were still working through your PowerPoint, so we didn't actually get into any of your slides yet when you
All right.
got cut off.
Okay, let me start at slide 3.
Perfect. Thank you.
Let's see if that goes out of the way. All right, everybody. Sorry about that. I was busily talking, and then all of a sudden I was being thrown off. So I'm going to talk about a bunch of things that relate to low-income households and their rights as consumers in the state of New York. I'm going to talk about the Home Energy Fair Practices Act. I'll also talk about Social Services Law 131S. I will talk about the Home Energy Assistance Program, about utility individual low-income assistance programs, the Public Service Commission hotline, and also the Public Service Commission complaint process. And then if I have any time at the end, I'll also talk briefly about current issues in the New York Public Service Commission rate cases and generic policy proceedings. So I will try not to talk too fast to catch up, but we'll catch up a little bit. So there are 3 areas of authority really in the area of utility consumer rights. One of them is utility file tariffs with the PSC. And forgive me, now that I've gone and been kicked off, my PowerPoint is busily telling us what it wants to do again.
Richard, would you like us to put up the PowerPoint?
Yeah, can you do it from your end?
Yep, sure.
And let's start from slide 4.
Sure. All right. I think you have to make me the presenter, though.
All right.
I can do that.
Okay.
All right, it should be coming your way, Becky.
Yep, I got it. All right, slide 4. Can you see it?
I can now, thank you.
Okay.
So the way that the utilities charge and the way that they behave towards their consumers is pursuant to, and you guys are skipping ahead too now also.
Yeah, I see that. I don't know what's going on here. Hold on. There must be, is there an automated thing on your?
I didn't think I set it up automated.
All right, let's just do it this way. I'm not quite sure why it's doing that, but in the meantime, let's do it this way. All
okay,
right.
so the way that the utilities relate to their consumers is pursuant to filed tariffs, which are, you know, properly and publicly filed rules of procedure, cost, and consumer remedies with the Public Service Commission. There are also Public Service Commission created procedures and rules via rulemaking. The PSC also determines the relationship between utilities and consumers through orders, and they also intervene in the relationship through their hotline and also through a formal either written complaint process or a complaint process with administrative law judges. Finally, the Office of Temporary Disability Assistance gets involved through their Home Energy Assistance Program rules and also through their Energy Manual, which is issued under the New York Social Services Law. Can we have the next slide? So in the area of utility consumer practice, there are endemic problems of high utility bills, and this is in part due to the fact that New York State has some of the highest energy prices in the continental United States. Of the 5 most expensive electrical utilities in the country, 3 of them are in New York State. Of the 20 most expensive electrical utilities in the country, 5 of the top 20 are in New York State. You'll also encounter, in addition to high utility bills, you'll encounter shutoff notices and actual shutoffs. You'll also encounter from time to time what are called deferred payment agreements, which are agreements to work out back arrears, and we will talk briefly today about how serious medical conditions factor into this, denial of an application for service, what you do in that circumstance, and then very briefly about the Public Service Commission hotline and the complaint process. Next slide, please. So you have this in your handouts, and I bring your attention to 2 things. First is the bright red line, and as you can see, as the bright red line goes towards the right-hand axis of the graph, you'll see that it is hovering just slightly over 700. And so in the middle of the year 2014, energy consumers in the state of New York owed in excess of $700 million in arrears greater than 60 days to the public utilities. By the end of 2014, early 2015, the number was roughly $800 million in arrears greater than 60 days aged. And the average was a little bit more than $750 in back arrears per household in the state of New York. The other jagged lines that you'll see are Con Edison at the top and the nice pretty blue. Under that, Long Island Power Authority. Under that, LIPA, and then the other electrical utilities. So you've seen over the past decade, really going back to '96, you've seen a more or less continual increase of the cost of electric in the state of New York and other types of energy. But along with that, going from 2005 to this moment and picking up speed very quickly during the Great Recession, you've seen a very large increase in back arrears of utility consumers. And therefore, if you speak to low and fixed income clients at one time or another, and I know you all do, you will talk with them about the fact that they're behind on their utility bills. Next slide. So by the end of 2014, New York State's major electric and gas utilities issued 7.2 million shut-off notices. A shut-off notice goes to a household. Households are, by average in New York, 2.6 people. So basically, an equivalent of 80% of the population of New York received a shut-off notice. As a practical matter, what it meant was there were a number of households that received shut-off notices again and again as a technique for trying to force payment by the utilities. But of course, it creates a great deal of anxiety and stress in the minds of your clients and constituents. Service was cut off as a bill collection measure to more than 268,000 households in 2014. And again, multiply that by basically 3 to get your actual number, and we're talking, between 750 and 800 and some thousand people had their power shut off as a collection measure in 2014. Con Edison alone is the state's largest utility, issued 2.8 million shut-off notices in 2014 and shut off service to almost 250,000 people in 2014. Next slide. So what do you do in those kinds of circumstances? Well, first, until the bill is at least 20 days past due, the utility is not allowed to do anything. They can't take a termination action. And then the utility must issue a final notice of termination, which is usually, depending on what part of the state, a very official-looking letter, sometimes with red borders around it. And they have to issue that at least 15 days before the actual shut-off date. So the earliest a termination can occur is roughly 35 days after the payment is due from the consumer. Next slide. So although this seems entirely reasonable and that everybody knows it, utilities are not allowed to terminate you on Fridays, Saturdays, and Sunday, public holidays, or any day that the utility's main office is closed. And we also add in the 2-week period between Christmas and New Year's Day. So basically, utility terminations, the actual shutting off of power or natural gas, can only happen 8 a.m. to 4 p.m., Monday through Thursday, not a holiday, and not a time when the office is closed, although you may find utilities that from time to time bounce up against this rule. Next slide, please. So one thing that's important to know is that if you have ever gotten in the case where you get on with a client and the client tells you that they are several $1,000s behind in their utility bills and that the utility is threatening to turn them off, what you need to know is that your clients have an absolute right to a written deferred payment agreement, and that is an agreement to pay the back arrears over time, and it must be offered prior to termination activity. So frequently the utility will act as if they're doing the client a favor to give them a deferred payment agreement. Frequently they will only do it verbally, which doesn't create any protections for your client, although the utilities enforce on any kind of remedies that they can have in that circumstance. But the important things to know about a deferred payment agreement is that they must be tailored to a customer's specific financial circumstances. The minimum you can negotiate them down to is 0 down paying the back arrears and $10 a month going forward. The deferred payment agreement, or DPA, must be in writing and signed by the consumer and the utility representative. And so frequently what will happen is they will require a client to have a fax address. They don't do this through email. So they'll fax it somewhere, whether to your office or whether to Western Union or Kinko's or something like that, and then it's signed and then faxed back. If you are unable to get the kind of outcome that you need for your client, the utility is intransigent or something like that, you can actually call the Public Service Commission hotline, and we'll have that number later in this presentation, and you can ask them to help negotiate it. And then if you don't get the kind of agreement that you think you should have gotten in the end, you can file a complaint with the Public Service Commission. And then finally, with the area of a broken DPA, if your client negotiates a deferred payment agreement and then breaks it, the utility can shut them off, and quite frequently they don't like to come back and give service unless there is a complete payment of the arrears, or in that case you might have to switch service to another member of the household, and I'll talk about that in a moment. Could we have the next slide, please? So every consumer in the state of New York has an absolute right to receive service from a public utility, and since we're talking about energy, from a gas or electric company. And they are not supposed to require any kind of written application. They are supposed to just pick up the phone when your client calls and ask for service. So these are exceptions to the rule when a utility can require a written application for service. So if service has been terminated to the person applying for a new service, or their service is subject to termination for non-payment of arrears, and they move somewhere else, the utility can ask for a written application. Second, if during any examination of the premises the utility finds meter tampering or theft of service, either, and this actually goes to whoever was in the property before your client, they can ask for a written application then, because unless there was some kind of legal action against whoever did the previous meter tampering or theft of service, there's no way to know whether your client was the one who did that or not. Finally, if the meter is advancing with no customer of record, in other words, a variety of theft of service, they can request a written application for service to that premises. And the last time when you can require a written application for service is when the application is made by a third person who is not actually the renter or the homeowner or tenant of record. Next slide, please. So within 3 days of making the application for service, if the utility is going to deny you, it has to deny you in writing and has to give you a written reason for the denial. You also have to be given the precise steps needed to qualify to get service. Again, they have a legal duty to serve everyone. And so one of the steps may be to agree to a deferred payment agreement. Another one may be an agreement to pay back a certain portion of an arrears. And usually the utilities will push very hard on this. They will ask your clients to get money from the 131S one-shot grant from the Social Services Department in all of upstate New York, or from HRA down in the city. They may, if that's not enough money, they may ask you or your client to go to their local church and see if they can get any money from the church. They may look for other ways to limit that back arrears when your client comes forward to reestablish service. And then finally, your client has a right to request review by the PSC of the denial if they think that for whatever reason the denial is unfair or unreasonable. And we'll get back to that issue of review. So what if you owe money from, what if your client owes money from an old closed account, either in another part of the state or even at the same premises? The utilities are required to offer a deferred payment agreement before they can deny service to applicants with balances due from accounts previously closed. So again, they will act as if they're doing your client a favor. They'll act as if they only need to give a verbal deferred payment agreement, but they have to offer a deferred payment agreement in writing, and they have to negotiate it down to something that is reasonable for the individualized circumstances of your client. In alternative, what is fairly common in parts of the state is that the individual who is the previous customer doesn't apply if for whatever reason they've been shut off, and some other member of the household applies, and the utility has a duty to serve those people without reference to the previous arrears owed by the person whose account it was in the first place. Next slide, please. Excuse me. So if service was shut off to a household member, Public Service Law Section 31, which is the second section of the Home Energy Fair Practices Act, says that service can be denied only if the applicant owes money from a prior account in his or her name. So again, service must be provided even if other household members owe the company money. So if, husband or wife was the one who had the previous service and was shut off, their spouse or significant other or, whatever the relationship is, can come forward and get service. Minors can't, but adults in the household can come forward and get service. Again, the utilities will fight against this, but this is guaranteed by law. Next slide. And I'll pause, by the way, after this slide is done, and we can have a chance to, I'll pause after the next slide, and then we'll have a chance to answer questions for a moment. So what if there's serious medical conditions? And this is actually in the nature of a practice tip. So if the utility customer or a household member has a serious medical condition that can be worsened by loss of the service, either electric or gas, you can keep the service on if you can get a doctor's certificate, really a letter. And telephone is good for 5 business days, but you should always just, right from the beginning, get a written certification that the customer or a member of his or her household has a serious medical condition. Can we do the next slide, please? So a written certification is good for 30 days, and has to contain these things that we have here: state registration number, doctor's name and address. It has to cite the name and address of the utility customer, and if it's not him or her, whoever has the medical condition in the apartment, the nature of the illness or medical condition, and a statement saying affirmatively that the illness or condition will be aggravated by termination of the service with reasons supporting his or her conclusion. So the issue has been litigated before. For example, it's a very simple one if you're talking about something like a oxygen concentrator, which used to be called an iron lung, and someone needs that to breathe, or if you have a home dialysis machine. Those are very simple. The utilities actually are used to that, and they react properly in that circumstance. It was litigated a number of years ago whether or not having to have electric to keep a refrigerator on to keep diabetes medicine properly refrigerated was good enough. The utilities counter in court was, buy ice buckets and put ice in and keep the medicine in that, but they ended up losing. So if you have cases that are around the margins of what might be considered a serious illness that could be aggravated by the loss of heat or air conditioning or electric, you may need to argue that. You may need to get the Public Service Commission to intervene or end up going to court. But by and large, the utilities are fairly good about this kind of thing. And let me stop here for a moment because we're about halfway through. Are there any questions?
We just have one right now. So let's see. I've seen many collection accounts for utility services on clients' credit reports. However, they currently have service and are not required to enter into a DPA. Is this because once it gets to collections, it is out of their system?
So there's, I guess, two pieces to that answer. The first one is that even though it wasn't contemplated to act in this manner in the Home Energy Fair Practices Act, when someone gets a DPA, and even if they're current with the DPA, the utility has, or I should say some of the utilities have had a practice of reporting to credit bureaus that the customer is still behind on a principal debt. And this is something that I think is going to require a change in the law because the commission, that is the Public Service Commission, doesn't seem to see the problem, which is ruining a generation of people's credit. With regard to the collection agency reports for whatever action they had to take to get paid off, that's actually something fairly similar. Once those have gotten onto your record, then they stick on your record for, depending on what kind of a debt you're looking at or a discharge, somewhere between 3 and 7 years.
Okay, so we have another question. If the utility denies the request to keep power on for serious medical conditions, how do you handle that denial?
What you immediately do then is you call the Public Service Commission hotline and you tell them that that is exactly what's happened, that a letter for a serious medical condition has been submitted and the utility has decided to deny it. And you immediately call because you'll get the instant access to the Public Service Commission during the hours the hotline is open, and they should require the utility to keep the service on while you go to the next step. And what I always advise is that a phone call is not enough, so you should always submit a complaint in writing in addition to whatever phone call you make to either the Public Service Commission or the utility. During the pendency of a complaint, the utility will be required to keep the service on. And so this is another one of those practice tips, which is first thing that you do when you're talking to your client who is far behind on their bills and is worried about a potential loss of service is you ask them if there are any people with medical problems in the household. You ask them if they're on any kind of safety net programs also. But second thing that you do then is if you have a credible reason to file a complaint, and this is one of those lawyer judgment calls, you should file the complaint because the complaint is a way of slowing the process down so that you can engage in some kind of negotiations either between you and your client and the utility or a three-cornered negotiation of the Public Service Commission getting involved too.
Okay, we have another question. My client's husband's name was on the utility bill. He left, it was shut off, and now utility is saying she must take on his arrears, I guess, because she benefited from it even though the husband never paid. should she take on a $5,000 bill to get lights back on?
Well, the legal answer is no. The practical answer is the utility is going to fight to try and get her to take on the responsibility for those bills. So in that case, send them a writing. If they say no to the writing, I would immediately then start the complaint process to the Public Service Commission, because they know the law. And what you'll probably end up doing, I should point out, is that the PSC, in fact, may ask your client to see if they can get a 131S grant to do a down payment. But as a practical matter, they're not liable for the debt of their spouse to the utility company.
Okay. So for now, I think that's all of the questions. And Richard, we've figured out what was going on with your transitions.
Mm-hmm.
So it's up to you. I'm happy to keep clicking through if you'd rather have control. I appreciate that.
If you don't mind continuing to click through, because
problem.
I was unclicking the automatic advance and it kept putting itself back on.
No problem.
Okay. So if we can go to slide 17. So we just actually talked for a couple of seconds about Social Services Law 131S, which is, this is what it did to me, which is generally called the one-shot agreement.
Maybe it didn't work. Sorry.
That was 17.
Yep. Go ahead. Sorry about that.
So generally what will happen in a circumstance, and we can go back and use the woman who was being asked to take on the multiple $1,000 arrears, sorry folks, of the former spouse or the spouse who left. And so what they'll usually do is they'll ask you to try and apply emergency HEAP to it. So you put in a request for emergency HEAP and you apply that to the arrears. Then they'll ask you to go and get money from the Social Services Agency, which is much easier again in New York City than it is in the rest of the state. And then they'll ask you to go to your church or whatever kind of affiliation that you might have that would come up with any money for that kind of thing. But the goal of the 131S payments was to get people out of problems of arrears with utility bills. You don't need to be eligible for ongoing public assistance to get 131S assistance. You must, however, be able to prove that you're a tenant and a customer of record of the utility. Even though you might be under a sanction for problems with other sorts of public benefits, you're still eligible for a 131S grant. If we can do the next slide. And if you are, you will get a written repayment agreement from the Department of Social Services if you're above public assistance eligibility. One of the things that's interesting, of course, is that OTDA, that is the Office of Temporary Disability Assistance, treats this entirely as a one-shot program. But the way that the law was written originally, and I believe that we're going to go back and try and get some changes to the law in the coming legislative session. But the way it was originally written is that if you were able to pay back your DSS 131S grant, you could go back and get it over and over and over again. And that was really an acknowledgement of the fact that for the huge majority of individuals that, you know, getting into these kinds of situations is something that happens from time to time, but they're back out of them again relatively quickly. Either someone moves out, someone loses a job, there's a divorce, or people split up, or that kind of thing, and then things are tight for a while, but that you can come out of that fairly quickly. And just to go back to the top, if your client is eligible for emergency assistance for adults, there's no repayment agreement required. Next slide, please. So every utility has a low-income customer assistance program. And by and large, there is some combination of reduced rates for low-income utility consumers. You have to qualify with the utility. It's an affirmative process. They don't just find you. Most of the utilities have some form of arrears management programs. The one that Central Hudson has, it's part of their HOPP program, is fairly aggressive, and depending on who you ask, is very effective in getting customers out of arrears. There are also free low-income energy efficiency programs that are administered through NYSERDA, and you can get a great deal of efficiency work and weatherization for free for your client if you talk to NYSERDA and they put you in touch with the right people. The utilities themselves and charities usually have some kind of additional assistance for people who have trouble with their arrears and have been unable to catch up based on either a DPA or a 131S grant. And then finally, there's also the Home Energy Assistance Program, what's called Renter's HEAP. So even for people whose heat is paid for through the rent, they're able to get small amounts of HEAP, which offsets the cost of the rent on an annual basis. As far as Home Energy Assistance Program, that is a first-come, first-served program. This year it opens up November 16th, I think, and it runs out of money very quickly because people who were in the program in previous years, unless they move or somehow lose touch with the program, are re-enrolled. And since the federal government has been reducing that program every couple of years since about 7 or 8 years ago, it's now about 37% less than it used to be on a federal level, and this is passed through federal money. If you have any clients who might benefit from home energy assistance, then they should get into this program as quickly as they can when it opens up. Next slide, please. So the benefit for renter's HEAP is teeny tiny. It's between $25 and $35, depending on what part of the state and a few other things. But the small amount of the benefit is less important than the fact that getting into HEAP at all is categoric proof of your eligibility for any of the low-income programs that the various utilities across the state administer. It also gets you into the discounted telephone landline lifeline program, which puts your phone rate at roughly $9 a month. And HEAP eligibility is a broader number than the programs such as TANF and other safety net programs. So getting into HEAP gets you a whole bunch of other benefits, and it's an easier proof than it is for certain kinds of other benefits programs. Next slide, please. So one of the questions was, what do you do if the utility doesn't do what it's supposed to do under the law? And what you do is you call the Public Service Commission hotline immediately, and you have the number in front of you. It's open basically from 9 o'clock in the morning till 7:30 p.m. at night. It's not the same as your complaint line, which is to file a complaint with the Public Service Commission. But the PSC hotline can get involved and can either get the utility to keep service on while you're filing a complaint, or they can do what's called a 24-hour reconnection, which in most of the utilities around the state is without cost. So the test is down at the bottom, and we're all attorneys so that we know how to formulate the request to the Public Service Commission's hotline to get them to intervene effectively for your client. Next slide, please.
I'm going to try this one more time. Go ahead.
Okay, sorry about that. I needed a little water. I was losing my voice. So a number of years ago, and those of you who read local politics and all that kind of stuff that talks about what the state is busily doing all the time, know that the Public Service Commission complaint process is being audited by the New York State Comptroller. And this is in part the reason for it. So several years ago, the Public Service Commission had their complaint taking and adjudication process completely redrafted, and it was redrafted by the utility complaint offices. So the way that it works now is that you complain to the utility, your client complains, or you complain with them. The utility then does what it does, and if you don't get a positive resolution, you then call the Public Service Commission and you ask them to, you ask to make a complaint. The PSC will send you back to the utility, and the utility will get one more shot at solving the problem in a manner that you and your client are happy with. If that doesn't happen, then you go back to the PSC and you file a complaint. You can file the complaint in writing, or I always suggest that you file it. I'm sorry, you could file it verbally, but I always suggest that you file it in writing. You can either draft a letter, or you can file the complaint online, and the PSC has a fill-in form on its website. At that point, you can ask the PSC to either provide a written decision, or you can ask to appear in front of an ALJ. Next slide, please. So once you've made your complaint, the PSC investigates the complaint, or they just bounce it back to the utility. The utility will then call back your client and say, the PSC has asked me to get in touch with you and to solve the complaint, and you may or may not get the resolution that you should get, unless you have, basically, we call it 3 calls to get 1 result, and so you always end up going back to the PSC. And I usually recommend that you ask for a hearing in front of the PSC as opposed to an informal hearing just on the paper. It's harder for the administrative law judges at the PSC to say no to someone who is staring them in the face and telling them their story than it is to just do it on a submission on the paper. Next slide, please. And this is just going through what I told you, which is if the utility doesn't give you the response that you want, your client has to go back to the PSC with a complaint again, and the agency then investigates the complaint, may or may not make a determination that is favorable to your client. Next slide, please. So at that point, if you have gotten through the initial part of the process and your client hasn't gotten the kind of remedy that you think that they should have gotten, your client should request an informal hearing. Like every kind of appeal process, you have a deadline. It's basically 15 days from the initial decision in the case. And again, I suggest the informal hearing. The hearing officer, depending on who you get, that is the administrative law judge or the hearing officer, may or may not act more like a mediator than a judge. I leave it to you all to figure out what sort of approach to them will get the best kind of responses for your clients. But I think on your side, a combination of willingness to live with sort of relaxed evidentiary rules, but at the same time, maintaining a sort of formal demeanor is helpful, but you should see what works for you. At the end of that hearing, you'll get a written decision fairly quickly, and again, you have the alternative of a paper review if you want one. Next slide, please. So at some point after that, you'll get a decision from the hearing officer. You have, again, a 15-day timeline to make an appeal over the ALJ/hearing officer's head to the full commission. That has to be in writing. It needs to show, again, there's some sort of magic language, but you need to show reversible error on the part of the hearing officer. So either reversible error or evidence that you weren't able to get access to at the time, and the company will argue no one or reasonably should have known, that sort of thing. But basically, it's an appeal on paper. Think of it as, in essence, an Article 78 without a chance to argue. The commission will make a decision at one of its public meetings, which happen roughly on the 3rd Thursday of the month, and they'll notify you of your decision. If you go on the Public Service Commission's agendas, there's one from the October 19th meeting. You'll see that there are a number of commission decisions in individual cases. And so you'll get a decision from the commission in writing. And then, next slide, please. If you don't get, again, the decision that you think that your client should have gotten, you have 120 days to bring your Article 78. And since the PSC is an administrative agency located in Albany County, your cases will be in the 3rd Department, which has been, depending on the makeup of the 3rd Department, has been not too receptive to individual consumers. So they've made it fairly difficult. But, as my law professor used to say, you brings your suit, you takes your chances. But at least by bringing it to the Article 78 posture, you have, you have done what you can do for your client, and you've taken advantage of all the opportunities to argue. And there's some, depending on what the case is about, there's some fairly good case law that's out there that you can argue if you then want to go for, if you want to continue after the initial Article 78 if you need to. Next slide, please. So, current issues of the Public Service Commission. For the past year, since November of 2014 and going on through this moment, the proceeding in front of the Public Service Commission that the utility project has focused most of our effort on is what we're calling the low-income affordability proceeding. And so over the past year, for the first time in history in the state of New York, the Public Service Commission has been moving towards creating a program that would create a uniform statewide low-income rate reduction program. And this is important because right now the rate reduction programs for low-income and fixed-income individuals in New York, so the poor, seniors, veterans, the disabled, all the groups that commonly need assistance in these areas. The programs for those individuals are administered on a utility-by-utility basis, and they are only in existence throughout the period of a utility rate case. So in the law, every year a public utility is supposed to come back and make an appeal to raise or continue its existing charges, its rates. So during that period of time, subject to a rate proceeding is the only amount of time that a low-income program actually has a legal existence at the utilities. And so on a utility-by-utility basis, each time they come in for a rate case, low-income household advocates have to come in and fight for a new low-income program. So we litigate the low-income programs utility-by-utility, rate case by rate case across the whole state year after year after year. And it's obvious that moving to a statewide uniform program that only needs to be negotiated once for the 7 major electric utilities, the 1 large gas utility, and the 3 smaller gas utilities around the state, that's a much better place for the state to be. On top of that, it gives us a possibility to broaden the eligibility criteria for all of the utility rate reduction programs. They're all different from each other now. And for that matter, the rate reduction benefit that's given out is different at all of the public utilities in the state. And so we're advocating for eligibility criteria that mirrors the telephone lifeline criteria, because it is much broader than any utility in the state except for Con Edison. And we're also looking for a percentage rate reduction, basically 30% of the customer's bill. And that would put us in the same arena, basically, as California and Massachusetts, which have been doing this, coming on a decade in those states. And we're just moving into this area now. The second hot issue at the Public Service Commission right now revolves around the energy service companies, otherwise known as ESCOs, who are the competitive retail energy providers. And there are 5 separate proceedings going on, but they're consolidated into 2, which are the ones that are most important. The first one is that in 2012, the Public Utility Law Project was involved in a rate case with National Grid, and we asked to look at 2 million records of customer bills in the National Grid service area. And what we found out was that on average, customers that elected to get service from ESCOs were paying more than $20 a month more than customers who got service from utilities. As a practical matter, something like 80% of the people who receive service from ESCOs were being overcharged. And when you move into the low-income, English as a second language, minority community customers, then you're looking at over 95% of those households are being overcharged. And so the most important of the 2 proceedings is a proceeding called the Low-Income Value-Added Services proceeding. And so what happened is after we got hold of the 2 million bills, we forced the Public Service Commission to have a proceeding to examine whether or not they should intervene on the pricing given by ESCOs. And that proceeding started in 2012. In 2014, they came down with an order saying that ESCOs were overcharging and they were going to take some action, but that was stayed by the commissioner, who then asked the staff of the Public Service Commission and the advocates, including us, to work out an answer to a problem, which is the order asserted that it would be inappropriate for an ESCO to charge more than the utilities rate unless it also provided a value-added service. Now, the advocates and the utility project have been fighting over what a value-added service means since February of 2015, and now we're 8.5 months into that fight, and we still have no agreement. But we're moving forward on a staff white paper because staff has been told to create a position from which the Commission can order what value-added services means and under what circumstances ESCOs can overcharge low-income consumers in New York State. The last thing, and then I'll take a few more questions, is something called Reforming the Energy Vision. And so starting in 2014, the state of New York, acting through the Public Service Commission, began a complete reform and reorganization of the way the energy grid works in the state. And as a practical matter, the energy grid now looks pretty much the way it did 100 years ago when Thomas Edison started serving electric down on Pearl Street in Manhattan. Except for things like nuclear power plants, the system works pretty much exactly the same as it did 100 years ago. But we now have things like renewable energy and storage and things like that that we didn't have 100 years ago. And so the Public Service Commission has been conducting a massive proceeding which has something like 20 sub-proceedings with the goal of completely changing the model by which electricity is provided in the state of New York, and also the model by which utility rates are made and charged. And so we've been extremely active in that proceeding. We ask everyone that we talk to pay attention to it, because if you have any contact with public utilities in the energy area, then your bills will change, the type of service you receive will change, and there'll be either opportunities or challenges affecting your clients. And so it's worth keeping an eye on. So, and as I said before, we have a website, we have updates all the time where we talk about what new things are going on in the utility arena in the state of New York. There tended to be sort of insider baseball updates, although sometimes they're just you know, reporting on what's going on, but a lot of times there's also sort of analytical thought too. And on our Facebook page, we're much more accessible, I think, for that kind of thing. But let me stop there and see if there are any questions.
Yep, so far we've got two. So let's see, in the past, once a welfare recipient received a grant under 131S, the agency was required to guarantee future payments. They would do this by taking out the utility portions of the welfare grant and sending that to the utility. And if the bill was higher than those portions, the agency had to make up the difference and then recoup it out of the grant. Is this no longer the case?
That does actually happen still in a number of the social services departments in the state. And one of the, it doesn't, and I should point out that to my knowledge that doesn't happen in HRA, but I think it does happen in many of the upstate social services departments. And I think this is one of those areas also that will require some corrective legislation as we go into the new year.
Okay, the next question is, are all of the day deadlines counted by business days?
They're counted by calendar days.
Okay. And so far, those are the questions.
Okay, so we have 4.5 more minutes. So why don't I just talk about this from a project tip standpoint then, since I think we can't let anybody go early if they want to get their entire 1.5 CLAs. So we operate an 800 number hotline, which is in front of you, 877-669-2572. And that is not, that's not basically for retail lawyering, it's for wholesale lawyering. So when we do a train the trainer kind of thing, when we talk to legal services groups in the state, when we talk to community-based organizations, and we do a longer version of the training with them, and we do a lot more question and answer, we then give them this number, and we tell them that you can call in, and you can ask us questions if you have questions that either the utility is not behaving the way it should be behaving under the law, or if they've posed a question to you that is unusual. We have our litigation attorney, staff attorney, Elizabeth Jorgensen, is the first person who will pick up the hotline, and she's located up in Syracuse. If for whatever reason she hasn't come across that question before, she'll then pass it on either to me or to our former executive director, who's still of counsel to the organization, Jerry Norlander, so one of us will answer it. If we are provided a question that we haven't encountered before or not in a long time, we'll certainly do the research and get back to you. And if it's really one that looks like it has broad effect across the state, we may then call you back and ask if we can get involved with helping litigate the case or providing, you know, any kind of help we can with your litigation of the issue, so that we can try and affect positive change in the law across the state. So with regard to what happens when your client calls you after this, I mean, the first thing, as I said, is to ask them, are they on any kind of safety net benefits? Ask them if they have any kind of, ask them if they or any members of the household have any kind of a severe medical condition. Because those are the things you should know up front, because, and also ask if they're seniors. If you know those things up front, those are things that even if they're calling you at the last moment, which in my experience has always been when a client calls, then you can slow the process down a little bit by taking advantage of the longer timelines that attach to those circumstances. As I said, I always advise folks, and this is something that you have to exercise your attorney's judgment with, but I always suggest that you try wherever possible to file a complaint with the Public Service Commission, because that also will slow things down and will raise the likelihood of your client getting a positive outcome. But you should prepare to, even with the PSC staff, that they are likely to try and get the utility to work out an outcome that is not exactly what you think that you might have been entitled to. So you may have to dig in and fight with the commission staff too, but that, of course, is in the nature of an attorney's job. So those are the kinds of things that I suggest when people get a client coming in with a utility problem. Other than that, I think that's about it. So have any more questions come in while I was talking?
I do, but before we finish out the questions, I just want to make sure that I think there was a misstatement. I don't believe that we ever intended this to be an hour and a half long. So I think we talked about that. Regardless, I think we're gonna meet the hour-long mark. But when folks are looking for their CLE credits, just be aware that you're going to get a 1 CLE credit for today. But there's lots of plenty of opportunities for you to get CLE credits from us, so hopefully that won't impact you too much, that half a credit. Okay, so we have 3 questions at the moment right now. For clarification, when a client is on public assistance, does social services have to pay for the Con Edison, that's the name of it, right? Con Edison. And if so, how much and what is done regarding any amount the utility charges in excess of this?
So in the case of Con Edison, you would go to the Human Resource Administration, to HRA. They have among the more generous 131S grants in the state. I don't know what their upper limit is now, but I'm trying to think who's the person that you talk to there. It's not Dan Tietz, it's the whoever asked the question, if you can send us an email to the utilityproject.org, that is info@utilityproject.org, I can figure out who the person is you should talk to there. But they will pay at HRA a fairly decent amount of the arrears. If the utility still has an amount of arrears left over from that, if we're talking about back arrears, then you're going to end up in a position for some kind of a DPA. Although I always advise people to see if they can get any additional money, any funds from their church or from any other kind of affiliate groups that they belong to, maybe some kind of neighborhood type group or that kind of thing. Was that the difference in the cost that the question asked, or was it an ongoing costs question?
I think it's a difference in the cost, but if I'm interpreting that wrong, maybe Janine, you can forward. Oh yes, she said ongoing cost. Yes.
So ongoing cost is a problem because you can get directly vouchered, and so the money goes directly to the utility from the social services agency. But when there is additional money, at least as far as I'm aware, and I'll go check and see if I'm wrong about this, but there's still going to be some bills owed at the end of the month, but hopefully not too much. And to my knowledge, HRA is very good also at negotiating to try and get clients into lower cost sections of the electric rates.
Okay, so hopefully that answers your question, Janine. So let's move along to the next question. This duty to guarantee the account has been a statewide policy set by the state DSS. How can there be variations county by county? Has the state changed the policy and left it up to each county?
What was the first part again? I'm sorry, I didn't get that.
The duty to guarantee the account. This is the same gentleman that asked the question about, I deleted the question before, I'm sorry, Philip, the DSS welfare grants prior. I think he's following up on that question.
Oh, so, and I may have misunderstood your earlier question, but for example, the Schenectady County DSS is somewhat more generous with 131S grants than some of the other counties are. But to guarantee, you may need to take that offline. If you want to reach out to me directly, my email is rberkley, that is rberkley@utilityproject.org, because I may be misunderstanding the question.
I think he's just asking why are there variations from one county to the next.
Oh, okay. Well, OTDA provides the background rules, but in general, much of the money that the local DSSs spend is money that's given to them in the nature of a block grant, and they have a great deal of control over the way that they spend it. So OTDA has overall rules for the way that they want to administer the programs, but once you get down to the county level, the counties have a lot of wiggle room for how they want to spend that money.
Okay. Hopefully that answers it, Philip. If you need,
and he can reach out to me directly, and we can talk about it too.
Right. Okay, the next question is, there are landlords who submetered their buildings and became utility providers. They do not give deferred payment agreements comparable to Con Edison, and they also try to evict tenants for non-payment of electricity. What can be done to make them separate, separate out how they behave as landlord from utility provider?
So if it's a formal submetering process, the submetering rules are also part of the Home Energy Fair Practices Act, and I suggest taking a look between Section 30 and 52 of the Public Service Law. But I think in that case, if they're not giving any kind of a deferred payment agreement, just throwing people out, then we should probably talk about it, because we get a lot of complaints about shared metering situations, and the landlords, more often than not, don't bother following the law. So we'd be happy to talk about it with you offline too.
Okay. So why don't we do this, Richard? I'm going to send your email address out to everybody. Let's see, I'm going to put it in the, where did it go here? In the chat box. Okay, so first of all, folks can just see at the moment that Shannon has put out, you'll see it labeled as probably Michelle Peterson. She's been sent out the CLE code, which is fallback. So please submit that with your paperwork to get credit. And then Richard, why don't you say out loud your email address again so that people can hear it one more time.
Sure. Let me give you first our 800 number, which is 877-669-2572, and it's also on our website. My email is rberkley, that is rberkley@utilityproject.org. And we're happy to talk to you folks about any questions you have.
Okay, so I've submitted both the number and your email address through the chat box as well. And let me just double check to make sure we don't have any additional questions. Oh, I think, let's see here. Yep, I think we're good so far with questions. So
okay.
If anybody else has ones, quickly just submit it. Otherwise, I just want to make sure that, Richard, thank you. I apologize for the hiccups here. I'm not quite sure what happened today. But I think we came out on top. So let's see. Just for folks to know, if you are a housing counselor, you absolutely can just get a certificate of attendance. Please submit the same documentation, and Michelle will get you a certificate of attendance if you're not looking for CLE credits. Richard, thank you so much. I really appreciate you on a last-minute request putting this together for us and making it work. So you were fabulous. Thank you. And everybody else, have a great day.
My pleasure. Good luck, everybody.
Thanks, everyone.
Take care.